What if I told you the IRS may have been using the wrong deadlines for years during COVID, and because of that, you might have overpaid penalties, interest, or even missed a refund entirely? Most people assume tax outcomes are fixed, but in reality, your structure, employee or employer, changes everything. And cases like this prove just how powerful understanding the rules really is. Welcome to Corporate Citizens LLC, where we help everyday Americans make the transition from employee to employer and onward to investor, because the tax code doesn't reward effort. It rewards structure, ownership, and strategy. Today, we're breaking down one of the most important recent tax cases, Kwong v. United States, a case that could reopen refund opportunities and change how COVID-era taxes are calculated. Here's what the court said. Under Internal Revenue Code Section 7508A, certain tax deadlines during COVID were automatically postponed by law from January 20th, 2020. All the way through July 10th, 2023. Not by IRS notice, not by policy, by statute. This is the key idea. If the due date moved, the math changes. That means penalties may have started too early. Interest may have been calculated incorrectly. Refund claims may have been denied incorrectly. This isn't theory. This is real money. But let's be clear. This is not automatic forgiveness. It's not a stimulus check. It's not a blanket refund program. This is a technical legal interpretation that creates opportunities, but only if analyzed correctly. Even more important, this ruling applies to older law before 2021 changes. So, this isn't a permanent rule going forward. It's highly specific to the COVID timeframe. If you paid late filing or late payment penalties during COVID, those may have been calculated too early. If you paid significant IRS interest, that interest may have started accruing too soon. If you thought your refund claim was too late, this case may reopen that window. This could also impact estimated tax penalties, business filings, international reporting penalties. Again, not guaranteed, but absolutely worth reviewing. Here's where it gets serious. Statutes of limitations still apply. In many cases, you may need to act before July 10th, 2026. Miss that, and the opportunity could disappear. Top advisors are already reviewing IRS transcripts, identifying affected charges, recalculating penalties and interest, filing protective claims. Because in tax, procedure drives outcomes. This case highlights something bigger. Tax law isn't just about rates. It's about rules, timing, and structure. And the people who understand that consistently keep more of what they earn. Kwong v. United States matters because if the IRS used the wrong deadline, your penalties, interest, and refunds may need to be recalculated. But remember, this is not automatic. Every situation is fact-specific, and the law is still evolving. If you think this may apply to you, don't wait. Visit becomeacorporatecitizen.com or call 516-476-8204 to speak with a professional. If you found this helpful, like, comment, subscribe, and hit the bell icon for weekly insights on business, tax, finance, and investing. The information provided in this video is for general informational and educational purposes only, and does not constitute legal, tax, or financial advice. Every individual's situation is unique. Please consult a qualified professional.